Hello and welcome to the Seniors Showcase 2021. I'm very pleased to be able to speak to you today about understanding consent and capacity. My name is Shauna McEachran, and I am an occupational therapist and a designated capacity assessor. I work out of the city of Kawartha Lakes and provide capacity assessments for people throughout the region. And during COVID times, I've been doing assessments for people across the province via video conference. So what is a designated capacity assessor? A designated capacity assessor is a health professional who's been qualified and designated by the Ministry of the Attorney General to determine whether someone can make their own decisions. So it's a mental assessment. It's a decision-making assessment. And so the legislation that describes what we do is called the Substitute Decisions Act. So in some circumstances, the Substitute Decisions Act is the legislation that gives an assessor the authority to determine whether someone has the right to make their own decisions or not. So who can be a designated capacity assessor? So any of the regulated health professionals, doctors, nurses, psychologists, social workers, occupational therapists, we're all eligible to become designated capacity assessors. We have to attend a course, a training course, and be approved by the Ministry of the Attorney General. And then there's quality assurance processes that we have to go through in order to continue being a designated capacity assessor. So during COVID, assessors are still working. It may be a little hard to find a capacity assessor right now because a lot of capacity assessors have full-time jobs in other places, in hospitals and long-term care and different things. So they've been extremely busy with their primary work. And also with the lockdown, it's been harder to visit people face-to-face because we can't go traveling around from one location to another quite as easily. So a lot of some assessors are offering assessments by video conference. And then if there's urgent situations or a video conference simply won't work or isn't appropriate, then we could do a face-to-face in those specific situations. Hopefully, once the lockdown is over, we'll get back to doing most of the assessments face-to-face with people in their own homes. So a definition of decision-making capacity is very important to start with because lots of people confuse capacity to make decisions with capacity to function or capacity to live alone. And so under the Substitute Decisions Act, a designated capacity assessor is looking at a person's ability to make decisions. And so in order to make a decision, somebody has to be able to understand the facts. They have to understand what is going on around them and what the facts of the situation are. In addition, they have to be able to appreciate the consequences. So appreciation is weighing out those options, the pros and the cons, and deciding if I did one thing, this might happen, but if I did something else, this might happen. So it's appreciating the consequences. So a clinician has to distinguish between poorly informed or foolish or socially deviant decisions, as opposed to decisions that are actually a product of somebody who can't think it through properly, somebody who's really not getting it. Because people do have the right to make bad decisions. Lots of times we make decisions that other people might not agree with. And as capable adults, we have the right to do that. And so it's a very important job to distinguish between people who simply don't understand or don't appreciate versus people who are making decisions that others don't agree with. So there are two types of capacity assessments and capacity evaluations. And just to sort of distinguish between the two for you, a capacity assessment is a legal assessment. So it's done under the Substitute Decisions Act 1992. And the big thing about a legal assessment is that it has the potential to change a person's legal rights from that point onward. So if a legal assessment finds somebody not capable of making a decision, then that person may not be able to make their own decisions from that point on. So a substitute or a guardian might be appointed. So legal assessments can be done by a designated capacity assessor for finances, for money, or by a judge for either money and property or for personal care. So those are the only ways that a legal assessment is done under the Substitute Decisions Act in order to change a person's rights. In contrast, a capacity evaluation is completed by an evaluator. So an evaluator can be any regulated health professional. So any doctor, nurse, therapist, social worker, anybody who proposes a treatment or a plan of care to somebody for medical reasons or proposes long-term care placement for someone, they have to do an evaluation to determine whether that person understands that decision in that moment at that time. So it doesn't change a person's legal rights moving forward, but it's a specific assessment for this point in time for this decision. And so people get easily confused about the difference because lots of times people have, for instance, the LIN or the home care program might find someone incapable of making decisions about long-term care, but that doesn't impact their decisions in other areas. It's strictly related to long-term care. So it doesn't impact their ability to make decisions about finances or medical decisions necessarily. So every decision has to be looked at separately under a capacity evaluation. So the Substitute Decisions Act of 1992, this is the law, the legislation that sets out the criteria. And so again, the capacity is the ability to understand and ability to appreciate in order to make decisions. Consent, on the other hand, is giving permission or agreement for the decision. So somebody gives you a decision to make and you agree to it or don't agree to it, that's consent. And then informed consent is what doctors and nurses and medical people have to get. And so that is a patient giving permission with full knowledge of what the risks and the benefits are. And so doctors, nurses, health professionals have a responsibility to teach people, to tell people what the risks and benefits are of the proposed treatment so that that patient can then make an informed decision about whether they want to proceed with that. The Healthcare Consent Act is an Ontario law, so this one's only in Ontario, but it has to do with consent to treatment. So it says that every person has the right to accept or refuse treatment so long as they have mental capacity. And that extends to admission to long-term care and also personal assistance services within long-term care or retirement home. So that law is very specific to Ontario and it's very specific to healthcare and long-term care placement. So when do I need a decision-making capacity assessment? When do you need a designated capacity assessor? There's not very many times when a designated capacity assessor is required or necessary. So the one place where we have exclusive authority is where the Office of the Public Guardian and Trustee is needed to become the statutory guardian of property. So if this is a case where somebody can't manage their own money anymore, they're not making good informed decisions, they don't understand the facts of their money, and they don't have anyone else to do it. There's no power of attorney, there's no family members willing and able to manage it, or they won't allow it. So the Office of the Public Guardian and Trustee becomes their guardian of property. And that's via an assessment and a finding of incapacity by a designated capacity assessor. The other way is if family members are going to apply to court to become a guardian of property or a guardian of personal care. So this most often happens with young people with disabilities. So once they turn 18, family members sometimes apply to the court to ask to be their legal guardian because they've got quite significant and serious disabilities, and there's really not any hope of them being independent or safe to make their own decisions. Occasionally it happens with adults. Personal care assessments are fairly rare because the Healthcare Consent Act covers off most of what we need. But if there's no power of attorney for money and there's no guardian for money, then a family member may choose to apply to be guardian of the money. And then sometimes people, when they write their power of attorney documents, sometimes there's a clause, a triggering or effectiveness clause in it that says, this may only be exercised when I am found to be incapable of managing property. And then sometimes it'll say something like by a doctor or by a designated capacity assessor. And so if the document says that they must be found incapable, but it doesn't specify how, then that will fall to a designated capacity assessor. Similarly, if it says, if it gives a criteria, but that criteria can't be met. So sometimes they say, if I'm found incapable by Dr. Joe Smith, but Dr. Joe Smith retired 5 years ago and moved to Australia, well, then that criteria can't be met. So then it might fall to a designated capacity assessor. So professional opinions of decision-making capacity, these are slightly different. So these are opinions. These are not legally binding, legally changing a person's rights, but they provide, they're usually done for due diligence, or they're done for different reasons to sort of give people more information about how somebody is processing their information. So examples of those might be capacity to grant or revoke a power of attorney. So a lawyer generally has the responsibility to determine that, but if the lawyer is uncertain, then they may ask for a second opinion. Capacity to write a will, same thing. The lawyer's the gatekeeper, but if the lawyer's uncertain or they're looking for a little bit more due diligence, then they may ask for an assessment, professional opinion. Banks or insurance companies, more and more are asking for a professional opinion of someone's ability to manage their finances before they'll allow a power of attorney to activate. Now, legally, most of these power of attorneys are perfectly valid and they're perfectly fine, but banks are covering their butts and they are becoming more and more reluctant to release funds, especially if it's a lot of money. They're reluctant to release funds without having something documented that the client is in fact incapable. So that's one way we're using them. And the other place is professional opinions regarding ability to make personal care decisions. Again, this is the exception, not the rule. There are very limited cases where this is useful, but it's mostly about due diligence. It's mostly about informing the decision-making ability of the family or the healthcare team to say just how much is this person understanding and appreciating their circumstances. And the other type of capacity evaluations, which are done by other healthcare providers, they might be done by designated capacity assessors, but it's not a requirement by any means. All healthcare providers can assess for capacity to consent to medical treatment. All healthcare providers can assess for capacity to share information within the team and with other members of the healthcare team. They can all assess for capacity to consent to support services like personal support workers, and they can all, evaluators can be any regulated health professional. The LHIN, or now it's called Home and Community Care, they're responsible for assessing capacity to consent to long-term care admission. So true or false? If a person has been assessed by a health professional as being mentally incapable for some purpose, then he or she is mentally incapable for all purposes. So this is one of those things that we come across a lot, and it is actually false. And very important that you go away from this in-service knowing that capacity is issue and time specific. So it relates to a particular task or a particular decision at hand. It's not global. So it's actually not at all uncommon for people to be incapable of some things and capable with other things. So a person may be incapable with respect to one more complicated treatment, but may be capable with others. So for instance, they might be able to make the decision about whether they should take those antibiotics when they've got a urinary tract infection, but they might not be able to decide whether they should have chemotherapy or radiation therapy if they've got cancer, right? The more complicated and the more risky a treatment, the harder it gets to make those decisions. And similarly, a person can be incapable at one point in time and then become capable again in the future, and vice versa. So even if a substitute decision maker has made a decision for someone in the past, that doesn't mean that the substitute decision maker always makes decisions from then on in. Imagine somebody's been in a car accident, they're in a coma, well then they can't make their decisions while they're in a coma, but once they come out of their coma, then they may be fine and they may be able to make those decisions again. So it's not something that gets triggered forever, it's something that gets triggered for that moment in time. And the other important thing for you to leave with is that for every person, there's a presumption of capacity. So it's up to other people to prove someone's incapable. It's not up to the patient or the client to prove that they're capable. So in every case, we presume someone's capable, and in every case, we have to have a good rationale and good evidence to suggest that someone is incapable before we can seek a decision from a power of attorney or a substitute decision maker. We don't routinely, and we shouldn't routinely screen for capacity. It's not a screening assessment. It's not something that we can do based on diagnosis. It's incorrect to assume that somebody has capacity or lack of capacity based on a diagnosis. So somebody with an intellectual disability may or may not be capable. Someone who's had a stroke may or may not be capable. Someone who's had dementia may or may not be capable. And it's also incorrect to assume a person is incapable by virtue of a score on a screening test. So the MOCA and the mini mental status exam, those are two very common screening tools for dementia. But again, just because someone has dementia, just because they have screened positive for signs of dementia, does not mean that they're incapable of making their own decisions, because decisions making is about processing of information and rolling that information over on their head. So somebody may have an impaired memory, but once they're reminded of the facts, may be able to have quite an intelligent conversation. So they might be capable still. So there's no standardized test for capacity. So you can't just pull a test off a shelf. They're all individualized. They're all very specific to one person's situation and the decisions that that person faces. And again, just to reiterate, you can't assume capacity based on any kind of a diagnosis. So things to think about. So let's think about Janie. She was diagnosed with dementia 10 years ago. She started out being a little bit forgetful, but over the years, things have progressed and she deteriorated. So now Janie often calls her children and her grandchildren by the names of her siblings. So she gets people confused. She needs help and reminders to bathe. She needs reminders to take her medication and to change her clothes. But despite all this, Janie insists that she's perfectly fine. And since she can still clean her house and pay her bills and go for walks with the dog, she figures that she's perfectly fine. So recently, though, the kids have been at the house and they've noticed several past due bill notices. And the bank has called with some concerns about unusual activity on her account. So this is a fairly typical situation where we sort of come across information sometimes quite innocently or just worries and concerns, and then we have to decide, well, is this just normal forgetfulness, or is there a pattern of behavior that we need to be worried about? So when we're thinking about how a capacity assessor would determine capacity for a person with dementia, we go back to our definitions. So understand and appreciate are our key components for decision making. So when we're thinking about decision making, we are looking for threats. What might be a threat to someone's ability to make decisions? So things like poor memory, limited insight, not knowing what you don't know, poor problem solving ability, limited cognition. So if somebody doesn't have the IQ or the mental ability to actually read and write and do different things, that may be a threat. They may have limited communication. I'll just stress, though, that communication, again, it's not an indicator one way or the other. So just because someone may have had a stroke and maybe can't verbalize the same way you and I do, that doesn't mean that they're incapable. They may be able to communicate with pen and paper. They may be able to communicate with sign language. They may be able to communicate using pictures and icons or gestures. They may be able to communicate using yes and no answers. So it doesn't necessarily mean someone's incapable because they can't talk. Impulsivity, disorganization, disorganized thinking, delusions. If somebody believes things that aren't real are real, that may impact their decision making. And concrete thinking means seeing black and white, only seeing black and white and not being able to see the other shades of gray and the other possibilities. They just see one option and that's it. So when we're looking at understand, we are looking for working knowledge of his or her financial status, health, or personal care status. We're looking to see whether they have awareness of any pressing issues that call for decision making. We're looking to see if the person has sufficient intellect and cognitive ability to actually process the information and think about the available options for what issues they face. And we're looking at their ability to follow an intellectual conversation and to problem solve around the facts of what's going on in their life. And appreciate, we're looking at the ability to actually manipulate the information and turn it over in their brain and appraise their options in a reality-based fashion. So if somebody is not in touch with reality, it's hard to make an informed decision. We're looking at the reasoning process. We're looking at the weight that a person attaches to one outcome versus another. Like, how bad would it be if this happened? And how bad would it be if that happened? And we're looking at their ability to problem solve and justify their choices with rationale. So asking why. Why do you want to do that? Why do you think that? Why would that be a good idea? So lots of why questions. And we're looking at their ability to consider those options of their own free will and not being influenced by others. So a capacity assessment does not remove someone's rights just because someone else thinks their actions are foolish or risky or outside social norms. We don't remove legal rights from someone who can problem solve and reason and provide justification for their choices, even if someone else disagrees. We do not judge whether a person's decisions or actions appear reasonable, but whether they're reasoned, whether they've actually been able to think them through and provide a reason for why they've chosen to do what they've done. And we don't consider if the person has functional or physical skills to live alone. That's a very common misconception. This is a cognitive test. It's a mental test. It is not about whether somebody can live alone or has the skills physically to live alone. And we don't offer suggestions or assistance in securing a place to live or what care someone needs. So we're not making recommendations for a plan of care. We are deciding who makes the decision about whether to accept the plan of care. So somebody else has to put the plan together. And my job as a capacity assessor is to decide who decides about the plan. So again, we decide who, we don't propose a plan or recommend a plan of care. So for medical treatment, long-term care, and personal assistance decisions, these all fall under the Healthcare Consent Act. And every time a decision falls under the Healthcare Consent Act, we have this hierarchy of decision makers. So no matter what, if someone is incapable of making healthcare decisions, there's always someone who will make those decisions for them. So the top three are legally appointed substitute decision makers. So some external entity through the courts, through a power of attorney, or through the consent and capacity board. If none of those, then we go down into family members. So family members automatically are substitute decision makers for treatment and long-term care. So we go down in order of preference: spouse or partner, parents or children, siblings, any other relative. If we've got no parents, children, spouses, then we go to any other relative who might be willing and able to make the decision. And if there's still nobody available, then we go to the Office of the Public Guardian and Trustee. They have what's called a treatment decisions unit. And that treatment decisions unit is the substitute decision maker of last resort. So if there's nobody else available, then the Office of the Public Guardian and Trustee automatically becomes the decision maker of last resort. And that doesn't require an assessment by a designated capacity assessor. This is strictly an assessment by the healthcare provider who's proposing the treatment. So this is a little bit of a busy slide, but it shows different, the decision-making tree as far as who makes the decision and what happens in different things. I'm not going to go through it in detail, but basically you can see it's a fairly complicated procedure in order to just derive whether the client makes the decision or whether the highest ranked decision maker makes the decision. Just one thing to note, the definitions for spouse and partner. Spouse, clearly, if they're married to one another, if they're living in a conjugal relationship for at least a year or have a child together, then they're all considered to be a spouse. They're not considered to be a spouse if they're living separate and apart as a result of a breakdown of their relationship. So if people are separated, they're no longer considered to be a spouse under this legislation. An interesting little loophole for families who live together, a partner is any two people who've lived together for at least a year. So it could be a mother-daughter, it could be a brother and sister, it could be two friends who have lived together for a year and are of primary importance to one another's lives. So it could be any combination of people living under the same roof who may get elevated to partner. So this is a situation that might arise if there's 6 children, say, and one of the children has been living with mom or dad for the past year. Then that child who's been living with and caring for their parent would rank higher in the hierarchy than the other siblings would. So if these equally ranked decision makers who can't agree on a decision, then that also gets passed to the public guardian and trustee, and they'll make the decision in place of the people. So this is a bit of a touchy spot that, if you've got 6 children and they can't all agree on a decision, then it will just, all 6 will basically just get put aside, and the public guardian and trustee will make the decision based on the best available information from the doctors and the hospital, not from the children. So just to know that just refusing to agree is really not going to be in the best interest of anybody. If they can possibly compromise, they really do need to. Otherwise, the public guardian will just make it for them. And so that, again, brings me to the public guardian being the decision maker of last resort. So if the client is incapable and there's no guardian, attorney, or family member, then the public guardian and trustee becomes the decision maker of last resort. Powers of attorney for property and personal care. So these are your official documents that you have to sign, legal paperwork, in order to choose who you want to make decisions if you can't. So I tend to think of these like an insurance policy. They're like insurance in case you get sick, in case you can't make these choices for yourself in the future. You're naming the person or the people that you trust the most to be able to do it for you. And there's 7 categories for power of attorney. In theory, somebody could choose 7 different people to be power of attorney, to be attorney for each of these areas. Now, in reality, we usually have finance as one document of its own. The other 6 categories all fall under the umbrella of personal care. And so in most cases, there's one person for all the personal care realms. But in theory, it would be possible to choose different people for different areas. So this is really important, that if somebody comes in and says that they're the power of attorney, we need to ask, well, power of attorney for what? Because the power of attorney for finance is not necessarily the power of attorney for safety or shelter or healthcare. So a power of attorney for personal care, a power of attorney is a paper. It's a legal document. It's not a person. The person is the attorney. The power of attorney is a piece of paper. And that's a piece of paper that gives another person authority to make choices on your behalf if you become incapable. And I can't stress enough if. So as long as someone is mentally capable of making their own choices about health, safety, shelter, clothing, nutrition, the power of attorney, the attorney has no authority whatsoever until that person is found to be mentally incapable. A continuing power of attorney for property, on the other hand, is a legal document that gives authority to someone to make decisions about finances. Now, this one is a little bit different because in most cases, these attorneys for property usually come into effect on the day they're signed. Now, you can put a clause in them to say that it doesn't come into effect until later, until there's some sort of a triggering clause, but most of them are signed to say they are in effect now. And they're called a continuing power of attorney because it can be used after a person becomes mentally incapable. So they're valid while the person's capable, but also remain valid when the person becomes incapable. So deciding whether the power of attorney is effective today is a very important thing. So most times the attorney has legal authority once the power of attorney document is signed and witnessed, unless there's some other clause. And then that clause could say it only comes into effect on a certain date or when they're found incapable by a doctor or somebody else. If the power of attorney comes into effect later, there's usually some specific directions about how mental incapacity is to be decided. And sometimes it's a letter from a doctor, sometimes it's a letter from another trusted person, an accountant, or if there's no other thing specified, then it's a designated capacity assessor who will make that decision. Is it active? Are there any restrictions? Is there more than one attorney? Do they have to work jointly or severally? So jointly means they have to work together. Severally means either one or the other can make decisions. So important again to read the fine print. We have to know exactly what that power of attorney document is requiring of the attorney. Instructions, conditions, restrictions, these are all little clauses that people can add. They're optional. But we need to, again, read the document carefully to know if there's different people for different decisions. Are there any limitations or instructions in the power of attorney? Sometimes people integrate their future care wishes maybe within the power of attorney document. So there might be instructions in there for things like cardiopulmonary resuscitation or for heroic measures, things like that. So we have to read the document to be sure. Does it require certain people to be consulted? It might say, my daughter can make these decisions, but she has to consult with my minister or with my rabbi before she can do it. So there can be certain clauses. And the law requires that instructions to an attorney in a power of attorney, they must be followed unless it's impossible to do so. So, and these instructions don't necessarily have to be written in a power of attorney. The instructions provided verbally by a person to their attorney must also be followed to the maximum extent possible until it's no longer possible to do so. So if somebody has said for years, I don't ever want to go to a nursing home, then it is the responsibility of the attorney to do whatever they can do to prevent somebody from going to the nursing home. And there will be limits, of course. There will be safety things that just simply cannot be managed. The money might run out. It might not be financially feasible to remain at home, but the power of attorney, the attorney is responsible to do it to the maximum extent possible. Personal care decisions. So Joe is 93. He's physically fit and financially well off. He's got a moderate memory impairment. But many years ago, he granted a power of attorney for personal care. He named his 2 sons to make decisions jointly and severally. So remember, jointly and severally means one or the other. Joe has lived at home since his wife died 8 years ago. He's got caregivers and support workers coming in every day. They help him with his meals and his cleaning and his personal care. But Joe has always made it clear to his sons that he did not want to live anywhere other than his own home. When he fell and broke his hip, he was sent to the hospital, and now he's having a lot of trouble walking. His medical team is recommending that he remove to a retirement home. They have concerns about his ability to manage at home. The boys are split. One really wants to send dad home and put whatever needs to be done in home. The other one really thinks that he should follow the hospital recommendations and have dad move into a retirement home. So first thing to remember is that the power of dad always trumps the power of attorney. So although the sons are legally the power of attorneys, the attorneys for personal care, we have to decide first whether Joe is actually capable of making the decision himself. If he is capable of making the decision himself, the boys have no say. If he's not capable of making the decision for himself, then the attorneys have some rules they need to follow. So the first rule is that they have to explain to Joe what their jobs are, and they have to encourage Joe to participate in the decisions. Joe might not be able to make the decision, but he can certainly give his 2 cents worth. He can express his wishes or his thoughts on the decision, even if the boys have to make the final choice later. The boys have to act in accordance with the known wishes of the grantor, if it's at all possible. And if they can't, then they have to act in his best interest. They have to keep records of all decisions they make. They have to facilitate contact between relatives, family, friends. They have to encourage and allow contact with all those people who might provide him with support and socialization. They need to consult with friends or relatives or other people who might have knowledge or thoughts about what Joe would like. They have to do whatever they can to facilitate his independence. His independence is really first and foremost to give him the most freedom with the supports he needs to maintain that freedom. They have to make decisions which are the least restrictive and the least intrusive, and they have to maintain comprehensive records. Property decisions. Similarly, so Bill, if we think about Bill, he's been to the game clinic and he's been making calls to the police after misplacing items around the house and then accusing caregivers of stealing them. And so while his son was there searching for these stolen items, he found receipts for hundreds of dollars in iTunes cards and money orders made out to unknown people. Bill doesn't remember buying them. He denies buying them. They also found collections notices for a cell phone bill that's not been paid. So many years ago, Bill went to his lawyer and he told his family that he did power of attorney documents, but none of the kids have ever actually seen these documents. There's 6 kids, and they don't know who has been chosen as the attorney. They haven't seen the documents. Nobody was really told. It was kind of that, well, Bill did them, but he didn't talk about it. And so now the lawyer has the original documents, but Bill refuses to tell the kids anything because he suspects they're trying to take over his life and steal his money. Okay, so paranoia and suspiciousness is a fairly common side effect of dementia and of not remembering things, because the brain wants to blame someone else as opposed to blaming his own brain. So property decision makers are simpler in a lot of respects than the personal care decision makers. So we only have 3 options for making property decisions. We have the client, we have Bill, either he makes his own decisions. If he can't, there are only 2 options. So an attorney for property, the person Bill chose to make those money decisions, or if Bill never chose anybody, then we have to look at getting a guardian for property. And that can either go through court or that can go through the public guardian and trustee. But this is where people run into difficulties. If you don't plan ahead, then there's nobody who can actually access the money. There's nobody who can pay the bills. There's nobody who can sell the house. We have no choice. If there's no attorney for property named, we have to get a guardian. And so that either becomes the government through the Office of the Public Guardian and Trustee, or that becomes a family member who is willing to go to court and ask to become the guardian of property. The guardian of property also has, so there's the 3 ways, as I mentioned. So you can go through the public guardian, family or friends can apply to the public guardian to assume the guardianship, and then the 3rd way is the judge can appoint a guardian. Note that the PGT will take over. Only family or close friends can apply to the PGT, but anyone can apply to the court. So if it's a friend, the client under guardianship has no legal rights to make those decisions. So the rules for the guardian of property, similar to the personal care one, they have to be aware of, and they're a fiduciary. So a fiduciary means they're managing someone else's money. It's someone else's money though, it's not theirs. So they have to do that diligently, honestly, with integrity, good faith, and in the best interests of the grantor. Again, they have to explain the powers and the duties and encourage participation. They have to facilitate the contact, consult with relatives, keep all records of all transactions, accounts. So I tell people this becomes the business of mom or the business of dad. You need to keep business records just like you would for running a small business. You keep all the receipts, you keep all the transactions, you keep all the bank statements, and you make note of where the money went in or out. You have to be aware that you're taking responsibility for managing the grantor's affairs, and there is some legal liability. So if you breach your duties, if you make some unreasonable transactions or you don't manage the money properly, then there could be some legal liabilities. So there's lots and lots of information, and there's lots of places on the internet where you can find more information about all of these things. I encourage you to have a look at some of the documents that I have on my website, and you can find lots more just by doing a Google search. You can visit me on Facebook or LinkedIn or Google. My own webpage is cares-ot.ca. And I want to really thank the Senior Showcase and all the organizers and the people who've sponsored and put this show together. Hopefully next year we'll be able to do these sessions face-to-face. But in the meantime, I hope you were able to learn some new information and help you to understand a little bit more about consent and capacity. Thank you very much.